Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Now, tonight's lecture is going to be on Chapter 10, where we are going to talk about offenses against public order and the administration of justice. And we'll talk about things like disorderly conduct and what constitutes disorderly conduct, and public fighting, and riots, and unlawful assembly, and loitering and vagrancy, and some of these laws that apply to that. And also we'll take a quick look at the Second Amendment as it relates to possession of firearms. So with that being said, let's jump right into the Chapter 10 lecture. So by way of introduction, on October 30th, 1991, at about 4 o'clock in the morning, New York City police officer William McGill was on patrol at the corner of 150th Street and Broadway. And while walking by a store that was still open, he observed a young man whom he later learned was named Paul Stephen. Now, Stephen was standing in the store, and as the officer walked by, Stephen clutched his genital area and basically yelled, "F you. If you were in jail, I'd F you. You'd be my bitch." And a couple of other expletives, and I apologize for the profanity, but this is what he said. Now, Stephen followed the officer out into the street, repeating the statements and yelling, "If you didn't have that gun and badge, I'd kick your ass, I'd kill you." Now, by then, a crowd of about 15 to 20 people joined the defendant yelling, "Yeah, F the police." So you can imagine the pressure on the officer then to deal with that kind of a situation, and really, what do you do? And, think about it. Do you have any type of crime? Well, let's kind of look a little bit further. Now, Officer McGill decided to arrest Stephen for disorderly conduct. And while the officer was attempting to restrain Stephen, the defendant struggled violently, flailing his arms, twisting and turning his body, and butting the officer in the chest with his head. Now, Stephen was jailed for a short while, and when he appeared in court, his attorney argued that his conduct was in fact protected under the U.S. Constitution's First Amendment guarantee of free speech, and that by Article 1, Section 8 of the New York State Constitution. So, needless to say, the trial court, there was a hearing, and I'm not going to read the whole trial court's decision. I'm just going to kind of go down to the end to give you sort of the end of what happening. Now, the defendant next argues, this is towards the end, that because the officer lacked the authority to arrest him for disorderly conduct, the resisting arrest charge must be dismissed as basically insufficient. In this case, assuming the facts stated in the accusatory instrument to be true, the officer arrested the defendant for exercising his constitutional rights to express his views regarding members of the police department, albeit in an extremely, basically crappy way. Yeah, that's not the legal term, that's my term. Because on these facts, no violation of disorderly conduct occurred, the officer was not authorized to arrest the defendant, as the officer was not authorized to make an arrest at the time the defendant struggled with the officer. An essential element of resisting arrest was lacking. Accordingly, the charge of resisting arrest is dismissed for insufficiency. Now, it's not always the same way in every single case, and you will come to see that freedom of speech, there are some exceptions, like yelling, fire in a crowded theater, or making threats against certain individuals, ones that you believe could be carried out. So you can't say and do everything you want to do, but there are some protections. So let's look a little bit about some of those. Now, before I start, I wanted to show you or tell you about 3 small video clips, and they're about probably 10 minutes apiece. And this is the anatomy of a riot. And it's basically narrated and discussed by those that were there in dealing with the aftermath of the Rodney King verdict. So it's very accurate, and it's extremely interesting to watch. And again, it's in 3 parts, and you can see and look at the different pieces of the riot and how they came together, and how some perhaps mistakes were made, and things that we can learn from in law enforcement as it relates to riots. So this is a great set of videos to watch. So what is a public order offense? Or what are crimes against public order? Well, this chapter, and I believe chapter 12, discusses crimes against the social order. And between the 2 chapters, 4 categories of social order crimes are going to be talked about. Crimes against public order and safety, which include disorderly conduct, breach of peace, unlawful fighting, and so on. Crimes against justice and the administration of government, including treason and perjury. And that's what we're going to talk about in this chapter, the 2 things I just mentioned. And then in chapter 12, we'll look at crimes against the environment and crimes against public decency and morality, including obscenity, prostitution, and other sex-related offenses. Our coverage, if you will, of social order offenses begins in this lecture with a discussion of crimes against public order and safety, and includes discussions of crimes against the administration of justice. And we'll throw in some of the environment. So public order offenses are those that disturb or invade society's peace and tranquility. And public order offenses include the following. Let's go through them each one. Breach of peace, disorderly conduct, fighting in public, or what they call a fray, and that's spelled A-F-F-R-A-Y if you've never seen that word before. Vagrancy, loitering, illegal carrying of weapons, and keeping a disorderly house, if you will. And we're going to look at all of these different sections as we kind of go through all of these. Now, laws criminalizing such activities rest on the assumption that public order is inherently valuable and should be maintained, and that disorder is not tolerated and should be reduced when it occurs through the application of criminal law. And this modern day assumption derives from an early English common law principle that held that anyone intentionally violating the peace decreed by the king in that time and desired by him for all of his subjects throughout the realm could be called to answer to the king's representative. So, and there's a couple other ones that we're going to talk of as well. So we'll look at public intoxication and disturbing a public assembly and inciting a riot and rioting and unlawful assembly and rout and all those different definitions. So what is the breach of peace? What does that really mean? Well, as some authors point out, all crimes, when viewed from a philosophical perspective, are breaches of peace and disruptions of public order. A murder, for example, is not only victimizes the individual killed, but it also violates the orderliness of social interaction, and it lessens the overall integrity of the social order. And some crimes, however, do not just theoretically disturb public tranquility, but are themselves actual disturbances of public tranquility or causes of such disturbances. And these are the crimes that concern us here. So the first one we'll look at is breach of peace. Now, this is a public offense done by violence, or one causing or likely to cause an immediate disturbance of public order. And many breach of peace statutes refer to this thing called fighting words. And we'll talk about a case in just a second. It's Chaplinsky versus New Hampshire. But let me give you a little bit more information. Under common law, breach of peace was the term used to describe any unlawful activity that unreasonably disturbed the peace and tranquility of the community. And breach of peace used today is kind of a flexible term, occasionally defined by statute for a violation of public order or an act calculated to disturb public peace. Breach of peace can also be described as a public offense done by violence, which I talked about, one causing or likely to cause immediate disturbance of public order. And the term itself embraces a great variety of conduct destroying or menacing public order and tranquility. It includes not only violent acts, but acts and words likely to produce violence in others. So a lot of times, again, we talk about, fighting words and things like that. And fighting words are words that, by their very utterance, inflict injury or tend to incite an immediate breach of peace. And fighting words are not protected by the free speech clause of the First Amendment to the Constitution. And a lot of people, again, they think they can say whatever they want. That is absolutely not true. The California breach of peace statute contains the phrase offensive words, referring to the use of fighting words. So let me give you a little bit more before we move on to disorderly conduct. So fighting words, again, are not protected by the free speech clause of the First Amendment to the U.S. Constitution, a position made very clear by the U.S. Supreme Court in 1942 in the case of Chaplinsky versus New Hampshire. And in this case, the court ruled that it is well understood that the right of free speech is not absolute at all times and under all circumstances. There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problems. These include the lewd and obscene and the profane and the libelous and insulting or fighting words, those that by their very utterance inflict injury or tend to incite an immediate breach of peace. And as the court explained, it has been well observed that such utterances are no essential part of any exposition of ideas and are of such slight social value as to step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. So in short, the court was saying here that the use of certain epithets or personal abuse is not in any proper sense communication of information or opinion safeguarded by the Constitution and therefore may be punished as a criminal act. So I think we've kind of gone through that one enough to show that fighting words again, by their very utterance, can be criminal. Well, what about this thing, disorderly conduct? And we have a long list, so I want to make sure I can get through all of these. Well, whereas breach of peace is a general term, disorderly conduct refers to a specific, purposeful, and unlawful behavior that tends to cause public inconvenience or annoyance or alarm. And because there was no disorderly conduct crime under the common law, the modern day crime of disorderly conduct has been created by statute. And one of the constitutional problems associated with attempting to outlaw disorderly conduct, however, is accurately describing just what forms of behavior make up an offense or constitute an offense. And at least one court has observed that disorderly conduct is a term of loose and indefinite meaning, unless it's written down by statute, but signifying generally any behavior that is contrary to law, and more particularly such as tends to disturb the peace or decorum or scandalize the community or shock the public sense of morality. Wow, that's a lot of stuff there. But again, it refers to specific, purposeful, and unlawful behavior that tends to cause public inconvenience, annoyance, or alarm. So a couple of cases to look at reference disorderly conduct, and I don't like the cases in a sense that they're good cases to talk about, but they're kind of ugly cases in a sense that we don't like to see what they talk about. Now, Texas versus Johnson talks about disorderly conduct and a case that deals with burning the American flag. And while we're not going to go there, I definitely wanted to at least let you know that there's a case out there that talks about stuff like this. So, you know, to lose the First Amendment protection of speech must actually cause or likely to cause a breach of peace. And speech that is offensive but doesn't amount to fighting words, or that doesn't create a clear and present danger to people, may not be censored or punished. So again, these two cases here illustrate the point. Texas versus Johnson, the Supreme Court upheld the right of Johnson to burn the flag of the United States as a form of political protest, even though most people find this form of expression extremely distasteful, if not disturbing. And the other case, Snyder versus Phelps, deals with the Westboro Baptist Church of Topeka, Kansas. And this is basically a church that protests the funerals of fallen U.S. soldiers. And they have signs that you can see believing that God hates the United States and that they rejoice in the deaths of the members of the U.S. military. And to make their point, they picket at funerals of deceased members of the armed forces. And again, it's not a great case to talk about, but it does talk about the rulings that come out of the Supreme Court sometimes. Now, you know, the court here, although this was very hurtful and offensive, the court basically said of picketing, and I'll kind of read you a very quick synopsis. Westboro believes that America is morally flawed, and many Americans might feel the same about Westboro. And funeral picketing is certainly hurtful, and its contribution to the public discourse may be negligible. But Westboro addressed matters of public import on public property in a peaceful manner in full compliance with the guidance of local officials. So, I mean, at the end of the day, the case sided with the defendant, saying that they did have certain rights to picket and express their views. So I have links to both of these cases that you can look at, reference forms of disorderly conduct. So again, speech that is offensive but doesn't amount to fighting words, or that doesn't create a clear and present danger to people, may not be censored. It doesn't mean it couldn't be, but it may not be censored or punished. And our country has chosen to protect even hurtful speech on public issues to ensure that we do not stifle public debate. And again, this isn't the time or place to debate it, but I wanted to make sure that you knew the information, especially relative to those two cases. Well, now let's get to that thing called fighting and what they call a fray. Now, one form of disorderly conduct that is often used to describe, or often described by statute, is unlawful public fighting. And although some fights may be officially sanctioned, as in the case of sports, etc., many others are not. And many jurisdictions have statutes outlawing a fray, which can be defined as the fighting of persons in a public place to the terror of people. And the term affray derives from the word afraid and means an altercation that tends to alarm the community. And, you know, when two people fight willingly and publicly, fight one another, both are guilty of the crime of affray. So just a little bit of information on fighting in public and this phrase that we term affray. Now, when we talk about alcohol and drugs, and we're not going to spend a lot of time on the actual definitions or get down into the nuances of different types of drugs, we're just going to touch on a couple of criminal aspects. So a few, well, let's do this. Statistically speaking, nearly 17.6 million adults in the United States are alcoholics or have alcohol problems. And 500,000 of those are between the ages of 9 and 12. And Americans spend over $90 billion on alcohol each year, which is just kind of unbelievable. So Americans surveyed, okay, let's go back to 2000, the year 2000. In 2000, almost 7 million persons ages 12 to 20 were binge drinkers, and one survey found that 25 million Americans surveyed reported driving under the influence of alcohol. And among young adults 18 to 25 years, almost 23% drove under the influence of alcohol. And the latest death statistics released by the National Highway Traffic Safety Administration, NHTSA, showed that 17,488 people were killed in alcohol-related accidents last year. And alcohol and alcohol-related problems cost the American economy at least $100 million in health care costs and lost productivity alone. And then finally, 4 out of every 10 criminal offenders report alcohol as a factor in violence, and 3 out of 4 incidents of spousal abuse are reported to involve alcohol by the offender. So the two main things that we'll probably talk about, the two most common things, are going to be driving while intoxicated and driving under the influence. So a few decades ago, 2 of the most common crimes involving alcohol were public drunkenness and driving while intoxicated. And the short phrase for that is DWI. And although both crimes are still quite common, DWI ordinances have generally been expanded now to encompass the operation of a motor vehicle while under the influence of drugs or alcohol. So that would be driving under the influence. So a couple of definitions: driving while intoxicated, unlawfully operating a motor vehicle while under the influence of alcohol. And driving under the influence is unlawfully operating a motor vehicle while under the influence of alcohol or drugs. Now, usually there are two separate crimes within the DUI. Okay, the first is a crime of driving while under the influence of alcohol or drugs. So that's one. And then the second part is based on the person's blood alcohol level. So some jurisdictions have established, two separate sections or two separate crimes, if you will, between the DUI category. So it is a DUI whenever a person operates a motor vehicle while under the influence and that person's blood alcohol level is immaterial as long as his or her ability to operate a motor vehicle is impaired. And the second type does not require that the individual driving skills be impaired, but only that his or her blood alcohol level has reached a certain level. So let's look at California as that two-prong example. So again, in most jurisdictions, there are two separate crimes within the DUI category. The first type of DUI is the crime of driving while under the influence of alcohol or drugs. The second type of DUI is the crime of operating the motor vehicle with a blood alcohol level specified by statute to be at or above a certain level. So California, the law is under the vehicle code, and it's 23-152, and subsection A says it is unlawful for a person who is under the influence of any alcoholic beverage to drive a vehicle. Section B says it is unlawful for a person who has a 0.08% or more by weight of alcohol in his blood. Now, it's also a crime to drive under the influence of drugs or something like that, but using the basis here for alcohol, you can see that there are actually two separate sections. And I hope that makes sense. Now, California, and like some other jurisdictions, have established a couple of other sections. So under Section C for California, it is unlawful for a person who is addicted to the use of any drug to drive. And Section F says it is unlawful for the person who is under the influence of any drug to drive. So California law kind of spells all these subsections out to cover all the different things. And if you look at Section F, especially now in California, with the legalization of recreational use of marijuana, you'll see the F section probably being used quite a bit more if, in fact, we see a rise in the level of driving under the influence of any type of drug. And then the other part that was talked about at common law as being one of the two crimes that took place quite often would be this thing called public drunkenness. And this is again, the second most common alcohol-related offense. And to constitute public drunkenness, one must, while in a public place, be in a state of intoxication to such a degree that one is unable to care for themselves, and in generally a location that is accessible to the public. Now, can you be totally drunk in your home? You can, if you're not causing any disturbances to your neighbors or things like that. But yes, this section of public drunkenness does not apply in your house, or generally does not apply at your home. And also, could you still be the victim of a crime based on the fact that you were voluntarily intoxicated to such a point where you were unable to care for yourself? And the answer to that is yes. You may not be able to have a defense. Remember, we talked about defenses, but you may be able to, of course, become a victim of a crime. So now let's turn our attention to riots and unlawful assembly. I really hope you had a chance to watch the Anatomy of a Riot video, because it does take you through the stages of how these things take place. So, in most jurisdictions, an unlawful assembly is when 3 or more people assemble for the purpose of committing an unlawful act, or of committing an unlawful act in violation of boisterous, an unlawful act in a violent, boisterous, or tumultuous manner. And unlawful assembly is a specific intent crime, and therefore requires that those who are assembled must intend to commit an unlawful act or a lawful act in a prohibited manner. And a rout can be described as the preparatory stage for a riot. And a rout occurs when an unlawful assembly makes an attempt to advance towards the commission of an act that, if carried out, would be a riot. The difference between an unlawful assembly and a rout is that a rout requires both an unlawful assembly and an overt act. So hopefully that kind of spells out what that is. Now, the third definition that we want to talk about just briefly would be a riot, and this is the culmination, if you will, of unlawful assembly and rout, and can be defined as a tumultuous disturbance of the peace by 3 or more people assembled of their own authority. So an unlawful assembly, again, a gathering of 3 or more people for the purpose of doing an unlawful act, or for the purpose of doing a lawful act in a violent, boisterous, or tumultuous manner. A rout is basically the preparatory stage of a riot. Remember, that's where there's an advance towards the commission of an act that, if you completed it, would be a riot. And then a riot itself is a tumultuous disturbance of the peace by 3 or more people assembled of their own authority. Now, the Federal Anti-Riot Act makes it illegal for any person to travel between states, or to enter the country, or to use any facility of interstate or foreign commerce to incite, organize, promote, encourage, participate in, or carry out a riot. So, staying with riot for a minute, to constitute a riot, there must be at least threats to use force or violence, and the threats or use of force must actually disturb the peace. And then there's something called inciting a riot. So let's talk a little bit about that. Now, as noted earlier, an unlawful assembly, rout, and riot all require a common person, or a common purpose by 3 or more people. And some states it might be 2. So I just want to let you know that there are some difference in numbers. The requirement of 3 or more people stems from common law, although again some states have statutorily reduced the number of participating people to 2. In any case, a single individual acting alone cannot commit those offenses. However, a single individual acting alone can commit the crime of urging or inciting a riot. And inciting a riot is the use of words or other means to intentionally provoke. To establish the crime of urging or inciting a riot, the prosecution must prove that the defendant's acts were done with the intent to cause the riot. So that brings us to another definition called lynching. And lynching is, I mean, the word itself is very demeaning because it meant something else, previous in the law. So lynching typically was the taking by means of a riot of any person from the lawful custody of a police officer. And any participation in the lynching is sufficient to constitute the offense. Now, it's not a crime of a single person acting alone can commit. And in some jurisdictions, they are now using the phrase prisoner rescue. Okay, and in more modern application of law, a single person acting alone can commit a prisoner rescue. So before, and some states still might use this, they still use that word lynching, which again, it's not a very good word to use because it could mean something different, or it's synonymous, if you will, with hanging in kind of olden days, if you will. So they've changed the verbiage to make it prisoner rescue. And while before it couldn't be carried out by a single person, some jurisdictions are now putting it statutorily in their laws that a single person acting alone can commit a prisoner rescue. And then lastly, disturbance of public assembly. This occurs when one or more people act unlawfully at a public gathering collected for a lawful purpose in such a way as to purposefully disturb that meeting. And it could be any type of public meeting. Typically, we run into this at a religious meeting, or perhaps even a city council or a city type meeting. And now that brings us to a couple of other terms, and we'll talk a little bit about vagrancy and loitering. So under common law, it was an offense to wander from place to place without any visible means of support, and most vagrancy statutes were eventually invalidated by state courts and the U.S. Supreme Court. And states that still retain this vagrancy statute have basically rephrased the description of the crime to require some specific form of behavior, because typically this type of crime, or the phrase vagrancy, is very vague. And I mean, think of it like this: is it really an applicable lawful procedure to criminalize someone for homelessness? And if you think about it like that, a lot of states, maybe it was criminal before, but now that's something that has been decriminalized because it's not a crime to be homeless. And that kind of feeds into the vagrancy application as well. And also, as it relates to things like loitering, that's another law, if you will, that has been statutorily changed because it was so vague. So as such, the common law crime of vagrancy made it an offense to simply wander from place to place without any visible means of support, and it focused on idle and those avoiding work. Now, later English statutes required that all able-bodied men need to work, and therefore that's why we had that law early on. And when common law vagrancy was enacted into the United States, vagrancy statutes were often again successfully attacked as being vague and overbroad, and as encouraging arbitrary enforcement by failing to describe with sufficient particularity what the suspect must do to satisfy the statute. So as a result of some of these flaws, again, most vagrancy statutes were eventually invalidated by state courts and by the U.S. Supreme Court, which in the case of 1972, the case of Paparchusco versus the city of Jacksonville, held that many traditional worded vagrancy statutes were void for vagueness because they failed to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden by statute, and because they encourage arbitrary and erratic arrests and convictions. Now, states today, again, retain vagrancy statutes, but they've been rephrased. Also, in terms of loitering, the phrase basically says it means to delay or linger or idle about a school or public place without any lawful business being present. This was also determined to be vague, and basically by specifying the circumstances under which loitering could occur, legislatures have also sought to de-emphasize a person's status as a determinant of criminality. So again, just it's a lot of legalese, but I want to make sure that we get through some of these points. And that brings us to weapons possession. And I'm not going to delve into really deep into the laws, but I do want to let you know that all 50 states, the federal government, and many local governments have laws regulating gun possession, ownership, use, sale, transportation, and manufacture. Now, the Second Amendment basically says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed upon. Now, the right to bear arms, however, it's limited because the states do have the right to regulate some laws, and some of those laws are those that involve firearm possession. So an example could be some states are open carry states while others are not. So some will allow you to walk around with a concealed or a visible firearm, open carry if you will, and some don't. And some of the laws, again, you can get a concealed permit, in some states you can't. So these are things that the states have the ability to regulate under certain circumstances. Now, under the federal law, the Brady Law provided for a 5-day waiting period before the purchase of a handgun and for the establishment of a national instant criminal background checking system to be used by firearm dealers before the transfer of any firearm. So again, I'm not going to delve back into all the firearm stuff. I just want you to know that, there are different laws in different states as it relates to firearm possession, and that the states do have the ability to regulate certain laws, just like the states have the ability to regulate, let's say, recreational use of marijuana. They also have the right to regulate some firearm laws. So immigration crimes, it is unlawful to bring certain drugs, plants, animals, and other substances into the United States. It is clear that the federal government has the authority to decide who may be admitted, albeit there are big disputes on that still. It is unclear whether the states share authority with the federal government to enforce immigration laws when they are influenced by immigration. Now, treason. So this is a crime against the administration of government. So treason is the attempt to overthrow the government of the society of which one is a member. And treason requires some overt act, such as affirmative encouragement of the enemy. And treason is a specific intent offense, and conviction for treason requires that the defendant must have intended to betray the government, if you will. A couple of definitions, if you will, that you'll see as far as treason goes will be espionage espionage and what they call sedition. Espionage is the unlawful act of spying for a foreign government, and sedition is a communication or agreement intended to defame the government or to, in fact, incite treason. Perjury. Perjury is the willful giving of false testimony under oath in a judicial proceeding. And to constitute perjury, the false statement in some states must be material, meaning that it needs to be significant and that it matters to the case. A couple of photos that I have here are from the O.J. Simpson trial, and if you remember, one of the lead detectives there was actually brought up on charges and ended up pleading guilty to a count of perjury as well. Criminal contempt. This is the deliberate conduct calculated to obstruct or embarrass a court of law, or conduct intended to degrade the role of a judicial officer in administering justice. And then finally, witness and jury tampering. It is a crime in all jurisdictions to attempt to influence jurors or witnesses outside of the normal process, and there are many laws against witness intimidation or witness tampering or jury tampering. Obstruction of justice is an unlawful attempt to interfere with the administration of the courts, the judicial system, or law enforcement officers, or with the activities of those who seek justice in a court whose duties involve the administration of justice. And finally, resisting arrest. That is obstructing or opposing a police officer who in fact is making a lawful arrest. Another definition, misconduct in office. These are acts that a public office holder has no right to perform, performs improperly, or fails to perform in the face of affirmative duty to act. Bribery. This is the offense of giving or receiving a gift or reward intended to influence a person in the exercise of judicial or public duty. And then finally, we're going to finish up with environmental crimes. Generally, environmental laws are intended to protect and preserve the natural environment, protect the health of the people, and to protect, preserve, and enrich the value of the nation's natural resources. And because there is no individual victim, environmental crimes are generally considered crimes against the public. And the Clean Water Act places limits on the pollutants that may be discharged into water and establish a permitting system, if you will, and it provides for both civil and criminal remedies for both negligent and knowing violation. The Clean Air Act has an objective to reduce and control air pollution. And so, you can see that there are a lot of different aspects to environmental crimes. And the Resource and Conservation and Recovery Act places controls on the generation, transportation, treatment, storage, and disposal of certain hazardous wastes. And it establishes a framework for the management of those hazardous wastes. And then finally, the Marine Mammal Protection Act is intended to protect marine mammals from extinction. So there are a lot of different things to cover under the Environmental Act, or all these other environmental crimes. You may not see a lot of those or deal with a lot of those if you work as a regular patrol officer, let's say, but in the federal environment, these are things that you could be subjected to or investigate. So with that being said, that's going to conclude our lecture on Chapter 10. And again, just as a reminder, make sure you go through and look at the summary that hits the highlights, the high points of a lot of the things that we talked about today, and also look at the key terms. the definitions, because there certainly are a lot, especially in this particular chapter. So with that being said, that'll complete or conclude our Chapter 10 lecture, and until next time.